My name is Darla Schembera, and this is my final presentation for Business 343 Employee and Labor Relations. Next slide. I have chosen case number 3, which is a grievance discussion. Safety gloves. Employee discharged. Was this a just cause? This case details the events leading up to the dismissal of an employee at the Barrera Recycling Company in Los Angeles, California, and her subsequent filing of a grievance with the union for wrongful termination. I will be representing the Labor Relations Manager for Barrera Recycling Company. As the Relations Manager, I will be looking at several main issues. Was management thorough in its documentation and implementation of discipline? Was there opportunity for the employee to correct the behavior? And was there just cause for dismissal? Next slide. I believe that there were several relevant portions to the collective bargaining contract for Barrera and the union that would justify this dismissal. First, in the General Purpose Agreement Article number 1, this speaks to employer and union wishing for the employee to be safe. It reads, in the mutual interest of the plants and employees to provide for the operation of the plants, the safety of the employees, and protection of property, it is recognized by this agreement to be the duty of the plants and the employees to cooperate fully, individually, and collectively for the advancement of said conditions. Other words, it's saying that the safety of the employees is part of the purpose agreement between the bargaining collective of Barrera Company and the union. In Article 20, Section 1, the reasons or causes for immediate dismissal are very clearly laid out. There are 14 conditions listed, and each of those individually could be cause for dismissal. Next slide. According to the case presented, the employee, Ms. Erin McNamara, has 20 years of seniority with the company and was transferred from Long Beach, Florida to Los Angeles in January. From January to October, Ms. McNamara was given 6 or 7 verbal reprimands from her manager, Mr. Gomez. Of the 14 conditions listed in the contract, these verbal reprimands cover at least 5 of those. Ms. McNamara was warned twice for sleeping during safety briefings. Twice she was reprimanded for not wearing her safety gloves. Once she was reprimanded for no hard hat, once for no safety glasses, and once for reading on the job. Sleeping and reading on the job, as you can see, are stated specifically on this list of just cause dismissal. Neglect of duty and disorderly conduct, in my belief, are demonstrated in her apparent lack of care for the rules and her flagrant disregard for any other employee's safety as well. She has seniority in the company, and by acting this way, she is showing that she does not care for the management, and she is showing newer and younger employees that this behavior is acceptable, instead of demonstrating a mentorship as she should as a senior employee. All of these items fall directly under the head of disobedience, which is also listed in the just cause for dismissal. Disobedience does not need any explanation, as all of those fall. Next slide. The last section of the contract that I believe is relevant to this case is stated in the Section 2 of Article 21, where it reads that management has the right to reprimand or warn an employee. Next slide. Any employer, not only those governed by a union, should have rules and guidelines for employees to follow. That should be in any company. According to Harcourt, it can be said that case law has determined that minimum performance standards must be established and clearly communicated sufficiently in advance to afford employees a reasonable opportunity to meet them. In other words, the employee should be given a chance to fix the behavior. In Ms. McNamara's case, she was given 6 or 7 different chances to correct her behavior. Then she was given a 3-day suspension. At this point, she should have been trying to comply with company rules in order to not only do her job well, but to keep her job. At the time of the suspension, she was given a note in her disciplinary notice stating, should you violate any Barrera rules or regulations during the next 12 months, you will be immediately terminated or discharged from Barrera employment. Next slide. According to Lexology.com, the website where lawyers collaborate and share articles with one another, it is typically the burden of the employer to show that just cause existed for the termination. Also, it should be noted that union workers are not at-will employees and can only be disciplined for just cause. Next slide. What I believe should happen in this case is the arbitrator for the 7 tests should use the 7 tests to determine if just cause was there. The 7 tests is a system that was developed by Carol Doherty in 1966 and is still in use by arbitrators today. Next slide. The 7 tests are as follows. Was the employee forewarned of the consequences of his or her actions? Are the employee's rules reasonably related to business efficiency and the performance the employer might reasonably expect from the employee? Was an effort made before discipline or discharge to determine whether the employee's was guilty as charged? Was the investigation conducted fairly and objectively? Did the employer obtain substantial evidence of the employee's guilt? Were these rules accepted and applied fairly and without discrimination? And was the degree of discipline reasonably related to the seriousness of the employee's offense and the employer's past record? In this particular case, yes, Ms. McNamara was forewarned of the consequences of her actions multiple times. The rules are indeed reasonable and are absolute for the efficiency of the company. Mr. Gomez, her manager, observed each of these incidents himself, so he is in fact the evidence and the witness. Since he is the witness of these events, there is no investigation needed, and the guilt of the employee is evident in that Mr. Gomez saw Ms. McNamara involved in each of these instances. The rules were applied fairly because they apply to everyone. And it should be stated that the sign for the gloves and glasses that was in Spanish in the lunchroom where Miss McNamara never goes, but she has been with the company for 20 years, and I believe that there's no way that she can state that she was unaware of the company policy on safety gloves, safety glasses, and hard hats. I do believe that the degree of discipline was indeed reasonable since she has been given 7 or 8 chances to correct her behavior, and each of these offenses in and of itself was serious enough for discipline and dismissal and could have resulted in grievous injury to herself or others. Next slide. In conclusion, I believe that this matter should be brought under a binding arbitration and that the final decision made by the arbitrator. When this happens, it will be the final recourse for Ms. McNamara and the conclusion of the matter for Barrera Recycling Company. Thank you. Next slide.